of questions that the legal side may find important to share with us.
Burk, I have been in the insurance industry for over 30 years. I absolutely love what I do. For 10 years of my career, marketing capacity, which means I place insurance programs for about 30 others. So in those 10 years, I think I saw it all. From individual proprietors, then went to the client side of things and absolutely roll it, transfer it, help them grow, scale. While I'm agnostic as far as types of business, all right, with respect to practice areas, cyber liability, technology.
I'm Razvan Miutescu, and I'm a technology, cybersecurity privacy lawyer, software. But probably so you'll probably see the headline go back to 2008, 2009, but they picked up in the early 2000s, 2010 with the experience, Equifax, as well as Yahoo, and now opinion not aware of what happened to the Uber and SolarWinds. Those are related but different topics. I think it's really important to be aware that the risk environment is very different. So that being said, we're focusing on insurance today. So even though there are lots of legal issues, we will eventually touch on those, and I will try to get out as much as we can about insurance and how insurance can address those personal liabilities. So let's talk. What should CISOs be worried about? What kind of liabilities are we talking about?
Right. Well, I want to start by talking about the emerging concerns facing CISOs, right? So the CISO role used to be pretty narrow in its scope, and now I think you'll probably agree it encompasses just a huge amount of responsibilities for you. You've got the frequency and also this variety of claims that are coming at your organization, threats coming at your organization is growing, as well as how sophisticated those attacks are. So they're just getting faster, furious, and really more sophisticated. I think this is probably the most challenging threat landscape that we've seen in the last at least 5 years, I would say. In addition, the attack surface of the organizations that you're working for is expanding, so that's just creating a larger and more complicated environment that you have to defend. So the CISO role is really difficult because you have to protect an ever-expanding environment against those ever-increasing volume of threats, but you have to do it in a way that doesn't restrict the growth of the company. So in other words, security can't bring friction that's gonna hurt the business that you're working for out in the marketplace, which is challenging. We then have those third party and supply chain risks. You know, that's just a huge concern. We don't have control over what they're doing, and we use a lot of third party vendors. Artificial intelligence. I know everybody loves it. It scares the lights out of me for a number of reasons. You know, so again, you CISOs, you have to secure the AI that your companies want to use within the business in a way that doesn't slow down your adoption of that technology. But frankly, AI is evolving so fast that now has the ability to turn around and be the source of the security breach. So AI is a really difficult one. And then frankly, there is an avalanche of new regulations that govern the work that you're doing. And it's the volume that's one issue, but it's also that, I don't know, I seem to think that in some cases, those regulations have different and sometimes conflicting demands. And keep in mind, they also vary by region. So the regulations are incredibly difficult to keep up with. So given all of that, it's really no surprise that the role of the CISO has never ever been more important. But with that, CISOs are now confronting pretty significant personal, civil and criminal liability as well. So it's important to understand why, but then to also understand that, yes, all of that can turn around and create liability for you. And what we're seeing is lawsuits as a result of a cyber breach can arise if a company experiences a cyber incident. You're going to have shareholders or regulators that are going to turn around and sue the leadership of the company. These claims come in the forms of claims for mismanagement, breach of fiduciary duty, failure to disclose cybersecurity risks. The SEC introduced new cybersecurity disclosure rules for publicly traded companies. These place significant responsibility on CISOs. The wording is they must ensure accurate, non-misleading public statements about security, prepare disclosures about risk management processes, and report materials of cybersecurity incidents within 4 days of discovery. In addition, CISOs now face fines up to $5 million and imprisonment for up to 20 years for willful violations of data accuracy and security protocol. So it's a pretty big deal. These are not small threats. Example of that Roz mentioned in 2003, Uber's CISO Joe Sullivan was convicted of a felony and sentenced to 3 years of probation for covering up a 2016 data breach. Another source of liability from CISOs comes from the statements that you make prior to a breach. If you've made statements about your company's security after a breach, those statements are going to be scrutinized and you can face liability for those. So what are the potential implications of a cyber incident for directors and officers and for CISOs? We're looking at potential securities class actions, derivatives lawsuits. You know, these aren't new, but SEC rules and enforcement actions, Department of Justice actions, financial institution disclosure rules are all being added. So really the landscape for directors and officers and for CISOs is that there are just many, many sources of, yeah.
And I think that's really important. And I'll try to expand a bit on the issue about the scope of the CISO job. It used to be that CISO, information security was kind of the key role. Now we're, at least from a legal standpoint and from a risk perspective, we're seeing privacy raise its head. And it's raised its head at an accelerated pace. But if we go back to 2016, 2017, that before the Europeans came up with the EU General Data Protection Regulation that we've all heard about. That was kind of a game changer for information security because it came with very strict, very complex data protection laws in the US. That's because the GDPR applies extraterritoriality to certain U.S. companies. To back up even more, the GDPR was this law that had existed on the book in Europe for 30 decades, starting in the mid-1990s. And before that, it was this law called the EU Data Protection Directive, or was the directive of the European Union. It had to be implemented by each country that was a member of the European Union, only conform. There was no uniformity. There was lots of litigation, lots of guidelines that were provided by regulators in Europe, literally over decades. There was precedent in history for this law. By the time it became big, you don't get up to it. What the GDPR did in the US is it triggered this privacy wave of law. So now we all know we don't have federal privacy law, but we're dealing with at least 20 depending on the comprehensive state privacy. What we don't have in the US is the kind of precedent, guidelines, enforcement, for the state, regulator settlement order with industry, arises out of enforcement of privacy law. Here, the CISO asked the lawyer, what is my risk here? And the answer is, this law came on the book, it's spread. Who was behind it, we don't know, because before it was implemented, it was not pursuing some kind of ideology that goes back decades. It's something that we got on the book quickly. It's written poorly. It's occasionally incomprehensible with respect to what it applies to and what it doesn't apply to. There's no enforcement history. There are no court decisions to help us interpret it. And some of these laws envision regulations that have not yet been adopted. So, good luck. Applying this, these kind of privacy safeguards for an organization. And of course, all of this has become kind of accelerated with the rise of AI because of it. So I just want to emphasize the point that we're in a really unpredictable environment where the stakes are getting higher and higher at a fascinating factor for this.
Back onto that, you mentioned the game changer. I think the game changer was my next example, which is the SolarWinds example. Right, so that was 2023. SEC alleged that SolarWinds failed to establish adequate security controls. SEC had brought businesses to task before, but this was the first time that they actually held the CISO responsible. And while many of the charges were dropped, ultimately they were convicted of fraudulent statements that they made about the SolarWinds running product. So I think 2023 was a game-changing year for this entire situation, and that now the finger is being pointed towards CISOs as well. So I definitely think that and the general accountability that you all have really is resulting in those potential significant liability, civil and criminal penalties. Yes.
Are you seeing organizations being proactive and trying to protect CISOs, even if the CISOs are not necessarily asking for that? Okay.
No, I don't, and I don't think that's, you may think, I don't think that's intentional. I just think this is an area that people think, well, I have insurance and we're good to go. And that's what we're going to talk about.
Okay.
Because, the CISO role, is the C in your name or your title the same as the C in
Exactly.
the CEO's role?
Yeah.
So yeah, that's exactly what we're going to talk about. And I want to make a statement before we move on to the next sort of section. We're talking about things that go wrong, right? Things that happen that are wrong. I do want to make a note, because there's always somebody that says, oh, I'm not worried about this. I talk to people. You don't have to do anything wrong to be sued. It's the being sued that's gonna cost you a lot of money. And I use this very basic example, but you know, I'm a great driver. I'm the best driver there is. I follow the rules. I wear my seatbelt. I stop at stop signs. I stay 4 seconds away from the car in front of me. But I could be sitting at a traffic light today and be rear-ended and pushed into the car in front of me. And guess what? I have liability. So you don't have to do anything wrong to be sued.
I second that. And we can get into this later, but that's where really the question, that's why it's important nowadays to look at the employment, both from the organization side and from the CISO side, to address this risk that historically has not really been. I think people assume that E&O covers directors. They may assume that management is covered under the bylaws of the company. They may assume that there is, simply because they have a checkbox for E&O that the situation is covered, but so that it's not all.
You indicated that was like 20+ state laws, not a national codified for treatment on regular. But I know that I think there's 6 states in the US now that have safe harbor laws. If you could prove you had reasonable cybersecurity, which is not defined in that level, but normally indicates you're following a standard like CIS or NIST, NSF, CSF, if you're not under like HIPAA or CISO. So I just wonder, is our insurance, do you see your industry moving towards requiring some type of framework as a way to help mitigate risk? And I'd also wonder from a legal perspective, like Maryland is really close to passing safe harbor. Getting these
You know, it's interesting. When cyber first became an issue, you know, back in 2009, 2010, for the mainstream business, you know, nobody had a budget for hiring a cybersecurity company, nor did they have a budget for a cyber policy. So most of them picked one, cyber policy, because it was cheap, dirt cheap. And frankly, the folks selling those had no idea what they were selling. They weren't asking the right questions. So what happened? We had a bunch of claims. Then the carrier started hiring people like you who actually know what they're talking about. And then came the requirements. Well, do you have MFA, EDR, NDR, you know, encryption? So to your point, I think the underwriting does take those into account. I mean, I haven't seen a specific question about do you follow NIST or anything like that, but I do think that what we see is as these exposures develop, you see more questions on the application and you see more scrutiny for sure. But we are, you know, a lot of what we're going to talk about today is exactly that. Even if you're a safe harbor, if you're following ABC, if you're not, what we're talking about today between the insurance and between other ways to manage risk about making you able to defend yourself by saying, look, and I do believe that everybody can put a case together. Here's what we did it with full knowledge and thinking. And I do think if you can defend yourself in those areas, that you'll be in a much better position.
From a legal standpoint, I think it's the safe harbors are not the kind of protection that people think they offer. First of all, in order to raise the defense of a safe harbor, you're in trouble. So you're incurring significant legal fees. People start counting the dollar of litigation. Second, safe harbor, the way they're drafted today, I think they're really focused on security. They don't really capture the broader context of data protection that captures privacy as well. So we're talking about CSF, we're talking about the cybersecurity thing. There's also privacy protection. That's 2021. The laws that have been adopted go beyond security. They may, if you read some of these state comprehensive laws, they don't focus on security. they're not technical. They really focus, they're inspired by the GDPR, they give the individual, the data subject, certain rights. And the breaches of those laws may not be security breaches. It could be a situation where you're selling the data, or you're using your database for training AI systems. Or there may be some kind of inadvertent use of the data that you did not know violated these laws. For example, you have a right to delete law. You delete the data up to a certain extent, but then you don't delete, you don't do backup, you don't delete it from all your databases because you don't have a comprehensive inventory of which business units process that individual data. This cybersecurity framework is not enough. That safe harbor is not really efficient. It can be found liable either under the statute if the statute that could give a private cause of action or not. But even if it does not give a private cause of action, the FTC and state attorney general's offices have been coming after companies under claims for unfair and deceptive practice. So they have these broad claims. You violate this law, will come at you for an unfair practice, not for data. Yeah, do we like it to be referenced in more predictive security program? Yeah. Let's say we represent from a legal standpoint, right? We represent a client who's hiring a service provider. I want the service provider to make representations about their services. So whatever those standards are, it will give at least the employer assurance that some kind of framework is followed and there's some kind of discipline for the executive I do. But the safe harbors are what they were intended to be when I started. Safe harbor.
Yeah, and that's a really interesting distinction. I didn't realize the safe harbor wasn't really tied to the data privacy aspect. The most important part.
That's how they started out, and if it does, it doesn't. It's really not targeted to retail to not sell.
Thank you.
I got a question I almost hesitate to ask in front of an insurance person and lawyer, but I'm going to go ahead and do it anyway. So with the patchwork quilt that we have of privacy law across the country, what defines a material breach? So let me posit a scenario for you. You're aware somebody has had their credits compromised. You're able to figure out where the bad guy looked at all the stuff they looked at. If the bad guy only looked at things, records of people who were in states that didn't have any of those privacy regulations, or what they looked at was information that was sort of outside the scope of what a individual state's laws define as, hey, you have to notify if any of this information gets out. What's the bar material for a material breach then at that point? If we're able to find that, hey, none of the data was exposed on anybody that has a data privacy regulation that required us to disclose, is that good enough? I know I'm asking a hair-splitting question here, but the definition with all these different laws, it leaves me to go, what is the bar that I'm trying to prove? If I have an incident, what bar am I proving to?
You'll probably have a better legal answer. From an insurance standpoint, I think the tricky part of this is that every one of those states has a different law. And that's what, so if there's a breach and you've got clients in 30 states, each of those states has a different rule about what requires notice, what is a breach. So I think I can't answer that question.
Yeah.
And I think that's one of the difficult things is that it's going to vary by state. And I hope one day there'll be one general guideline, but I don't know where that falls. I think that's the most challenging part of this is that every state is going to tell you something different. I mean, down to how you notify, is it email, is it letter, is it certified letter? And how often, or how soon after completion? It's impossible.
In that notification, in partnership with CISO and a privacy officer or a general counsel, is it the responsibility of the general counsel and privacy, like legal team? Should that be defined? Is that assumed? What role or what responsibilities does the CISO have to do the reporting? Because we're not really supposed to be doing the reporting. So is it the responsibility of the GC legal team? Should we define that? Is that assumed? Or how do we?
I'd be interested in your response on that.
So we're getting in the hairy area.
That's fine. You don't have to answer it. That's fine. Okay.
And I won't say that to deflect in any way. I'm trying to break this down. Sam's question basically pertains to, there is an incident that doesn't by law, at least if we read the law, does not require re-notification to be given. Is that,
It depends upon whose data got compromised.
okay, so I think there are different reporting standards. If we're talking reporting to the SEC, and the materiality factors that we're asking, because that's different.
I'm even saying, hey, somebody got a hold of your name and address and phone number when they shouldn't have, because we had somebody give up their password and somebody looked at your information and they have your name, address, and phone number.
So here's how,
Simple example.
so that's,
Some states would say you have to, others might not.
I love that example because it's simple and I can walk you through how I would process it. First, the first question is, I want to know this individual in what state does this individual reside? Is this individual subject to any specific laws? What's the name, access, name, telephone address, whatever, was it access in the context of patient health? Or was it in the context of a financial institute that subject to GLBA? If we're dealing with, let's say that didn't happen, it was simply contact information. Then I would go look at these 20 state laws, depending on where the individual resides. These data constituted. Then we will look at, okay, if it does, then we have re-notification obligation with respect to that individual, two individuals, potentially two attorney general officers. If this data breach was broader, maybe we need to publish in the media, whatever. Then we go to the next step. What other reporting obligations are there? And we may need to go beyond what the data breach law. We would look at the public, the traded company, will the SEC regulations apply. Then we look at this disclosure, this unauthorized access constitutes materiality. We get into the materiality, and it's kind of both materiality and the impact, financial impact on the company and on the operations of the company. That's where there's a cottage industry for this, it's disclosure lawyer that handle this kind of stuff. And you look at what's the risk, what's the impact on operations. And you think, do I need to file an 8K, do I need to file a 10K? Let's say this is not public. So if it's not from a publicly traded company, you're not subject to these specific laws. Am I, I was not yet, because you need to look at what are some other commitments, privacy or confidentiality commitments that we made with respect to this data. And this data on could be data you collected under your website privacy policy. That's a contract. It's a public contract. If you're telling people on your privacy policy, like many people do, we will let you know, we have all these great measures in place, not something happens, we'll let you know, we gotta give notice. If you're the kind of organization that is where secrecy is important because maybe it's an effective group that is maybe politically targeted, your membership to that group is protected. You would probably have some kind of duty to notify the individual based on the group. So that's how I walk through that analysis of.
So it sounds like our incident response process and analysis needs to take into account locality of the impacted data records as a part of that overall process, and then make branches
And I'm
that.
gonna add to that, that you also need to look at the cyber policy under what triggers a data privacy event. Because time is incredibly crucial, and I mean minutes and seconds, not hours and days. Like, that needs to be reported, it needs to be reported to, historically, data shows the sooner you react to something and get the whole team working on it, the insurance behind you working on it, the better the outcome's gonna be. So to add the insurance piece.
So I think when we sign off on the questionnaire, there's something along the lines of, has there been a reportable incident or something along those lines, and it's like, okay, that's a lot in that word, what's that actually? What am I saying?
That's very quickly when we talk about policy, the word matter, the words really.
So I think. These are great questions. We have a lot of. And let, how can we address these types of liabilities through insurance, cyber?
So now that we've like scared it to death, now we're gonna talk about, how do you protect yourselves? Or do you just say, I'm not doing this, I'm gonna go do something else? Well, I'll recommend that. You guys are carrying the greatest risks that your companies you work for have. So all we're saying is you also need to add in managing your own risk. And that's what we're gonna talk about. So D&O insurance, directors and officers liability, known as D&O insurance, may cover claims brought against directors and officers for failing to implement proper cybersecurity procedures and protocols. Cyber insurance may cover the cost to mitigate the breach, and the third-party part of the cyber policy may cover claims brought by those individuals who were affected by the breach. Why do I say may? Because if they're not written correctly, they very well may not cover you. So that's an important word. When we come down to words are important. So obviously cyber insurance and D&O are very different. Cyber insurance is going to respond to the effects of a data breach, while D&O is going to shield the leaders of the corporation and the entity itself from their resulting claims from that data breach. Here's where it's difficult. The policies are not universally applicable. So every one of you works for a company that's different. Insurer A may not insure your company. So you have a different insurance policy than you have and than you have. So it's very different. Standard policy language, if you look at a standard D&O policy, that's fine, but all those forms attached behind it change the coverage. So there can be endorsements that really broaden coverage, cover gaps, limit exclusion, but then there's exclusions. So if you're going to look at any part of the policy, you need to look at the exclusions because they change the contract. And this is just where it gets very, very difficult. So every one of you is in a very different situation. D&O policies provide coverage that arise from liability to a third party. So the entity coverage we're talking about, a public company, is that coverage is really limited to securities types claims. Private organizations coverage is broader, so that's good news. And that coverage typically includes defense, damages awarded, judgments and settlements, etc. But here's where it's important. So following a cyber incident, the availability of any D&O coverage is really going to depend upon those policy exclusions. That's why you really need to be cognizant. You need to ask for the policy and you need to read the exclusions. Some insurers are attaching specific cyber exclusions. We don't want that. We need to get those removed. You can have D&O exclusions related to contractual violations, unlawful conduct. I mean, these exclusions sort of come in all shapes and sizes, so you need to really pay attention to them. And a word to the wise, any word in a policy that's bolded is defined. So if you haven't read a policy, I challenge you to do it, because if you hit a bold word, then you need to go back and look at the definition of what that word means. So it's not easy. You can find bodily injury, property damage exclusions in D&O. Obviously, those are coverages covered by general liability, but that can include invasion of privacy, which is often what we see worded in the cyber claim. So again, these are all important words that we need to take a look at. Cyber policies, you guys are probably pretty familiar with that, right? These are the kinds of policies that come in after you've had a breach, and they do a number of really, really valuable things. So they cover the costs to engage the breach counsel. These are the folks that are going to help you determine, okay, do I need to notify? And how do I need to respond? And do I need to respond to regulators? Hiring those forensics folks that come in and tell you, did you actually have a breach and what was taken? Incredibly expensive. So that's a cyber coverage. Again, if you have to notify those stakeholders or provide credit monitoring, the cyber policy will provide coverage for that. Your own computer network could be damaged by a cyber breach, so cyber will address that as well. Some of your businesses may have a high public visibility issue. So if you're in healthcare or a financial institution and you have a breach, the public relations part of the cyber policy could be very, very important to you. So that's something to look at also. Obviously, defense costs would be covered, damages, settlements, judgments that come from that. And business interruption laws. I always like to talk about this because a lot of clients don't think that a cyber breach could necessarily cause them a large business interruption claim. In our office, the largest cyber claim we've ever had with any of our insurers was not a usual suspect. No PII, no protected health information, no personally identifiable information, handful of employees. They manufacture products, and the manufacturing process is run by computers. But when those computers were infected by a virus, it shut them down for 2 weeks to the tune of $500,000 of lost income. So an important coverage. Cyber policies are great. Not all are created equal. They're very different. So again, a point to be looking for these coverages, making sure they're there. So these are the two policies that will respond. One to the cyber breach, and then the D&O is going to come in afterwards to respond to the lawsuits that follow the breach.
And quick question, how do we ensure that the CISO is covered by D&O?
And that's why we're here. That's a great question. It's a really difficult one to answer. So we know that you have a great deal of responsibility, and with that responsibility comes a great deal of risk. So it's really imperative that a CISO is covered under your company's D&O policy. It's providing you a safety net. I mean, from those personal exposures, financial loss, reputational damage. So are you covered under your company's policy? I don't know. It gets really tricky because every one of your companies has their own charter and their bylaws that say who's an officer. And then I mentioned before, every one of you has a different policy contract. What does the policy say about who is insured? Is it limited to directors and officers, or do they add employees? You have to look at the definitions. Many companies just don't consider the CISO, even though the C's in your name, they don't consider you an executive like they consider the COO, the CEO, or the CFO. So in those cases, you may not be picked up automatically and be covered by those policies. And in those instances, we urge you to be affirmatively added. I mean, endorsed onto the policy as a covered individual. We call it being added by belt and suspenders. So really important, if there's any gray area, make sure that you have been added to those policies. You want to have individual coverage. We call it side A coverage of the D&O. So if the company can't stand behind you or won't, or maybe they're bankrupt, that part of the D&O policy will stand behind you as long as you're covered.
Could you repeat that? Would you say side A?
Side A. It's called side A of the D&O policy. Covers, will cover you if the entity is won't or is unable to for any reason.
I'll just make a comment here. Side A coverage for D&O policies can help both the CISO and the company. We all understand that CISOs are under enormous pressure. Some people just don't want to take on the role of CISO because of the responsibility and potential liability that comes with it. So having a solid side A D&O policy to protect the individual personally can be kind of a benefit, a market, something that organization can come forward with as something to give assurances to the CISO that we're here to protect you. And importantly, when some of the things that a lawyer will go through is, will the company actually defend you under the policy? And will legal fees be covered? Will legal fees be covered if I tell you that you're not covered by our insurance or employment agreement? These can be elements that you can give to a CISO to give them more comfort with the organization and the fact that the organization is behind them while they're doing this good job.
That's great information, especially in this environment where it's really difficult to find good qualified people and get them to stay. I mean, that's like an employee benefit. That's another one.
Yeah.
Same topic, I'm just wondering, like, I'm working with like a 500-person entity, they don't have a CISO, but they have a security officer on their HIPAA policy.
My
Same logic applies to anybody that's-
Like- planted there.
Let's make this one point, then you can get into that question. On the flip side, the CISOs should ask to see the side of the green. It's weird. It's
What do we look for? In the side A, that is,
what do you look for?
yeah, I mean, if I'm asking for it, I have to know what I'm looking for in the
Right.
side A.
I mean, I have to, say it depends, but basically what you would look for is look at your role and responsibility.
Gotcha.
So, I would need to back up on this, because when you're asking for the insurance policy to look at it, you always review that in conjunction with your employment. And in particular with a section, there are two important aspects of employment. One is the role description. You want to make sure that you're really comfortable with the role and responsibility that you take on. The second one is indemnity, which is, will the employer indemnify you? Also save you harm. And defend you in the event, by contract, this is not the thing that gives you harm. In the event of the claim. So then, by looking at these few sections, you really have to think about, what would a claim look like? Let's talk more about this. But yeah, the claim, we all think we understand what a claim is. But these insurance policies with their defined terms are very vertical. So once you understand what the job description is, what your indemnity kind of right, maybe we want to make sure that the insurance coverage gives you protections with respect to what kind of claims could arise out of your role. It could be investigation. You want to make sure that even weird stuff like having to attend deposition. So when you get subpoena, the company pays for it. And more importantly, you want the insurance company to pay for that stuff if the company goes on or they go into bankruptcy. Because that employment contract, the protection of the afforded employment contract will not mean much to the company in bankruptcy.
Thank you.
So I think Melissa was gonna.
I was gonna address your question about, there is no CISO. So should just the CISO be named? No, I mean, you can have a CISO equivalent, that is making statements. So really, if the company considers them an officer, then they should be covered. So you really, companies need to be very in tune with who is doing what. And back to your point, roles and responsibilities, that actually go a long way to helping prevent some of these things, is following that protocol of who's doing what and sticking to it. But, you know, if somebody's disclosing information, then we need to make sure that that's documented and that there's backup for those statements that are being made. So there really needs to be a continuum of information. Whatever's going out there publicly needs to be backed up and documented, and whoever is making those statements needs to also be covered. So again, if they're not a CISO, we can add anybody to the policy, and companies should want to do this, affirmatively added to the policy to make sure that they have coverage.
What if they don't, do that? Like companies don't add the system to the policy, something like a doctor, where they go get their own individual coverage?
No, because the claim is gonna be due to the work from the company. I mean, I can't imagine why a company wouldn't want to protect the people. I mean, they're gonna find themselves without a CISO.
I think that's a legit question, and you probably have to think long and hard if you want to work with them.
But just to be clear, I think what you're saying is, you have to assume that if they don't want to defend you, they're expecting something to come along. But the insurance in the first place is if something randomly happens, it's not expected, right?
Well, not necessarily expecting, but they're calculating risk, and they're basically taking the position that they don't want to take that risk on you to defend it. So, and to your point, it doesn't have, the title doesn't have to be CISO, and I forget which one was, if it was Yahoo or Equifax that they're bringing some time back, also started. Some of the defendants, if you had information or security or information security in your job title, you were a defendant with the law. So, this really applies if you're a CIO and you want to apply the same kind of reason, the same kind of text.
So then, I mean, anybody with that role then, who's not an officer, not a director, should potentially see the kind of coverage they have from their employer.
Technically, yeah, if you have the leverage to do that, will organization have every person from their IT department, there's no problem. Because the risks are much smaller than go. But the risk is there. We haven't seen that happen.
I think it enhances, again, the importance of roles, clearly defined roles and responsibilities. Who is doing what? I think that's crucial. And if everybody's staying in their lane, then we're not maybe having this gray area so much. I will say some policies can be pretty broad, and they'll pick up, you know, anybody involved. So it's much broader wording, then we don't have to worry about it. The key is, and the message is, look at those policies, look at every part of those policies. And not just the base policy, you need to really importantly look at all the endorsements, the ones that add coverage, the ones that take coverage away. And then your corporate charter. Are you an officer by definition? And if not, then you need to be added. So I think that's what it boils down to. You know, cyber is much easier when looking at who's insured. Most cyber policies, and again, you need to read it, but most cyber policies are going to cover the entity, employee, and even independent contractors who are working on your behalf. So that's a much easier one. The D&O is where you really need to pay attention, because that's where the lawsuits can come from, and they can be on a much larger scale for you individually.
So maybe we can wrap this up in terms of the presentation with final thoughts on what else can CISOs do.
Yeah, and I think this is the most important part. You know, I told that example of, okay, you know, I'm a great driver, but I still need to buy insurance because I have liability, so I don't do anything wrong. Okay, so I buy an auto insurance policy. Well, does that mean I can just do whatever I want? I can blow through stop signs, I can drive 80 miles an hour? Well, no. What's going to happen? I'm going to have a bunch of claims. My insurance carrier is going to drop me. So we can't just now, we've talked a lot about insurance, we can't just rely on the insurance. We have to manage the risk from all angles. And insurance is a critical part of it. Obviously, I want to make a note about the information on the cyber application. This is a big one. You know, when we send out our renewal applications, we're sending them to our primary contact, usually the CFO or the CEO. Well, when it comes to those IT questions, are they answering them? Or are they getting their CISOs involved? Because I'll tell you, we've had a problem before, but I thought we were doing that. That application becomes a warranty. So at the time of the loss, the adjuster's coming in there and saying, wait a minute, you said you were doing these 5 things and you're not doing them. Guess what? You just paid for a policy that isn't going to cover you. Nobody wants to be in that spot. So the cyber application is really important. Other things, I mean, obviously having really good internal cyber hygiene, that's what you guys do. Security protocols, but educate everybody on those protocols. And we see a lot of claims come from employees, sometimes intentionally, most times by accident. So it's really important. And then also create awareness of threats. You know, this can be very simple, but very effective. We did it. We had a Tuesday morning meeting years ago. We made a note that, hey, this, you know, we're seeing wire instructions be intercepted. They're changing the routing numbers, and it was just noted. Well, a year later, one of our young producers was buying a house, and he got his wire instructions, and he thought to pick up the phone, and I'm glad he did, because his had been intercepted. So again, creating that culture company-wide is really important. Have a data breach plan in place. Not many of my companies actually do this. Super important. Have one and practice it. You don't want to be doing this when you have a claim. You've got to practice it. Who's even at that meeting? Phone numbers of the insurance, and this should all be in one place. You shouldn't be running around saying, hey, you've got the cyber policy. You need to have all that information, because again, minutes and seconds, not hours and days, is where it's important. Obviously, all the things that you're doing, all the controls, MFA, encryption, I don't need to tell you that, you all know that. Internal governance, and I think this is a big one, right? What's the structure? How does the information flow? Who's responsible? And that helps ensure that decisions are made responsibly. We want to stick to that. Communication, are we communicating with all of our stakeholders? That's another key element. Those clearly defined roles, legal, audit, risk, who's doing what, and whose knowledge is required in the event of a claim. That's super important. Another note, the resources behind the carrier. I'm talking about cyber carriers. If you have, and there's a lot of great cyber carriers. If you have 2 carriers that have really equal coverage, but one carrier has really great resources, legal firm or law firms, they've got great companies, forensics firms, that's worth way more than the other company. So really look at the resources that come with those carriers, because that's helpful. And a note about legal, and a lot of times clients will say to me, I've got representation, I want to use my folks if I have a data breach. The time to decide that is when you're buying the coverage, not at the time of the claim, because you're not gonna have any traction. So, but what I have found, and it might be different for you, but I don't know, but 9 times out of 10, when I approach that attorney and say, okay, the carrier is going to consider letting you be counsel, but I need this information. Most of the time they come back and say, no, I'm counsel, but if they have a breach, I'm not your person. So if that's the case, then you want to get that claim put in ASAP, because as soon as you do, everything's, you know, cloaked in that confidentiality, and those minutes and seconds are important. So just a note about that. And to kind of wrap it up, I truly do believe, and this goes back to what you said about a national sort of framework. I'm of the opinion that executives and CISOs can avoid legal punishment as long as you can demonstrate that you made reasonable attempts at security. You were honest about those, that's key, right? And then you can explain the steps that you've taken. So I think that's really a crucial part of it. And that really requires the things that we've talked about, the roles, responsibilities, the accountability.
Well, sorry to interrupt, but I think that is absolutely key for a system. So document. If things go sideways, it's really important what you have documented, because people will start asking for documents. When you're subpoenaed, or if you have to be a witness or to testify, what you did, what you said doesn't matter as much as what you prove through documentation. And what you want to note the point, what you want to prove is that you've taken good faith steps towards substantial compliance. And that can get you off the hook with many claims.
And I'll say again, just to wrap it up, you guys are in the risk management business, that's what you do. So manage your personal risk. I think you can avoid the liability. It's just understanding and knowing how to do that. I hope we've given you a little bit of guidance on how to do that. It doesn't need to be difficult, but it needs to be in place for sure.
I asked a couple of questions.
Absolutely.
So, we've talked a lot about this, and we're so grateful. We'll do an official clapping and thank you after. We're so grateful for you coming and sharing your expertise. I had a lot of conversations with people about this. I think there are a lot of risks, or a lot of myths, I should say, about what those risks are. So how does this impact like a CISO of a public entity, like a county or a city or a state government? How would they manage their risks? Same way, or?
I think it's gonna be the same way for sure. A lot of exposure there. So again, it's very, very important that there's affirmative coverage for that CISO there. Because in those cases, there's a lot of scrutiny, you've got shareholders, public companies, they tend to hit the media. So it's really the same, but I think a greater exposure. So again, if you look at the SolarWinds example, now keep in mind, some of those claims weren't covered. Criminal charges typically not covered, but again, those folks face significant fines and imprisonment. So again, I think all of these things become very important. Documentation. Any statement that is made needs to have documentation behind it somewhere. I think that's key.
And then if someone is a fractional CISO or a VCISO or something like that, we have a lot of those among our members. How is that? Just how does that play out?
Virtual CISO, outsourced CISO, same analysis.
Okay,
Look at the contract.
so it'd be like an SLA or something like that. Okay. Okay.
With respect to the government CISOs,
Yeah,
what we haven't really negotiated a lot. I've looked at one
okay,
arrangement.
sure, 'cause I know their insurance.
Yeah, so I haven't really looked at
Okay.
that. I can probably speak to the contract, but not too much to the
Gotcha.
intent. Make sure that the insurance coverage.
Sure,
Meaning the government technically can go back and do, so we want to protect the part.
thank you.
Melissa, you said, data breach plan, practicing it, is that different from incident response plan, or is that under an incident response?
I would say the same.
Okay.
Any incident, I would just have a plan.
But, okay.
It's really important. We talk a lot, we're in the insurance, but I think more than selling policy contracts, we're talking about managing risk, especially since COVID, right? So you need to minimize the risk first, and then transfer by buying insurance. But things like crisis management, Superstorm Sandy, COVID, really it needs to be part of your overall plan. Like, what happens if? It's all about I'm big on building a resilient culture. Like, we don't know what's gonna happen, but we can do everything in our power to fill the gaps. And then what happens, but it won't hurt us so much. It'll allow us to get back into business if we have the insurance, if we have the protocols, if we have the backup documentation. Everybody knows who's doing what, the stakeholders know. Then we're just creating an environment where we can bounce back from that relatively quickly. If we don't have all that in place, you can go out of business for having a cyber claim that's not properly covered. Be easy, yeah.
Any more questions?
Yeah, I got another one of those questions. Okay, so if my cyber insurance carrier also offers forensic services and all of that as well, I'm kind of torn between the, oh, happy, joy, they can come in here and help me, and the fact that from a privity perspective, their contract is with the insurance company, as I understand it, not with me. So when all the bad stuff starts going down, the fallout, maybe I wasn't able to investigate or find things in our logs that maybe these forensics folks find. Talk to me about the fact that they're not working for me now. They're working for the insurance company. And how do I, as a CISO, but also as a company, protect ourselves from the very people that are going to come in to help save the day? I know it sounds kind of like a convoluted question, but I'm just thinking here, we think we've got everything sewn up, and the forensics guys come in here and say, oh, no, you didn't. And now all of a sudden, the whole thing, because we brought in insurance, is now completely out of my hands, and all the fingers start pointing back at our organization. How does that play out in the real world?
Well, my experience is unless there's fraud on the application, you've got a policy contract in place. The policy contract is designed to protect you. So they're gonna come in, do their assessment, and if there's a covered loss there that is dictated by the policy, then they're on the hook for that. Now, they can come in and say, hey, we found fraud because you said you were doing all these things. The breach came because you didn't. Then you could be looking at not having coverage at all. But the policy is a contract. As long as the carrier can't negate that because of fraud, then whatever that contract says is what the carrier has to do. I mean, it's a contract like any other contract. Now, sometimes we have to get involved and say, hey, we're interpreting this differently. That happens. That's where the Goodman Golden Gable came from, right? I'm not saying it's easy, but the policy contract prevails. So
it's like seems to be in their best interest to say, oh no, well, hey, wait a minute here. Yeah, he didn't do that. And they've got forensics people here that are basically not necessarily operating in their best interests. And again, I'm asking the paranoid questions here because it's not what if you're right? It's what if you're wrong.
Right. Well, I think if there was an intentional, I haven't seen that. Again, if you say you're doing it, you better be doing it. So again, going back to the importance of that application, because if the carrier says this claim happened because you didn't have multi-factor authentication and you answered 6 times that you did.
Yeah, but that's an easy, it's kind of the fuzzy ones in between where it's like, maybe I couldn't see it, but they're going to bring in people that have resources that are going to see things I didn't. And then the question becomes, well, you should have known that. You should have had those resources at the table. But obviously, if I could have, I would have had it.
We haven't run into that. I'm not going to say it's not going to happen, but I haven't run into that. What I see is typically when the claim happens, there's coverage affirmatively, then the carrier is going to do everything in their power to keep the claim costs low and to cover it.
So that's what's in the best interest.
I haven't, but
So I have not personally come across that situation. I think it's one of those risks. It's a business decision that you take on. It's possible that but it's not that much different from trusting that the cybersecurity firm you bring in, if you bring in an forensic team, that they will do what they need to do in order to help you out, as opposed to them, moving on, all clear.
But the insurance company is going to look more for, are you not doing things you say you do, then why aren't you doing this thing that you didn't do?
So they could, I haven't seen that happen. Okay. What I've seen do is these forensic investigation firms, they don't work for one insurance company. It's rare. Some do, they have their own internal investigation. They work for multiple insurance companies. Some have the insurance business that's just one of their units, not all of them, so they have a reputation to protect in the market as well. It's a small community. I just haven't seen that happen. I don't see how that would be prevalent. Could it happen? Sure, but they would have to really dig in.
what I've historically seen with the forensics folks, and I they get really interested in finding out what happened. And a lot of them even get excited and they're like, I see this similar footprint to something else. And so that I don't think that they're even involved in the other part. I think they're sticking to their role.
But what I've seen is the opposite, where there is insurance coverage and the forensics come in, they look at unpaid encryption, the application probably says there is an unpaid encryption, but they don't care about that. They're just moving on. So
They're paid to be with.
there has to be a high level of, I think, fraud for the insurance company to say on your application that all these things.
It comes down to that more than maybe error of omission, because I didn't think to implement a certain control was going to be necessary
Right,
type of thing.
Yeah.
the carry and require it, you're not lying about it.
You know, I'm dealing with two cases right now where there was no MFA or MFA was enabled, but off.
Back to this application, everyone, every
Yeah, it is.
stakeholder needs to be looking at that application before it's signed and sent. Really important.
So, any more questions or? Ready to wrap up? Thank you all very much for bringing Melissa. Thank you.
Thank you, brother.
Yeah, we appreciate all of you. Thank you again, UMBC Training Centers. You did say the entire length or for at least the hour. You know, we will send you a CPE certificate just by default. You don't need one, you can just delete it, but if you need one, you'll have one. Thank you. Thank you. Hope to see you guys at an event soon. Yeah. Just kidding.